Hello, I'm Yvonne Dutton, one of the ILW Program Committee co-chairs. I have the pleasure of introducing our keynote speaker this Saturday morning, Judge Julia Sebutinde of the International Court of Justice. And before I go on, I want to thank organizing committee member Nawi Ukabiala of Debevoise and Plimpton for making the introduction. Nawi served as a legal officer to Judge Sebutinde. Julia Sebutinde was elected in 2011 to be a judge on the ICJ and is the first African woman to serve on that court. Before serving on the ICJ, Judge Sebutinde was a judge of the Special Court of Sierra Leone, where she served as the presiding judge in Courtroom 2, responsible for, among other things, overseeing the case against Charles Taylor. Prior to serving on the SCSL, Judge Sebutinde served on the High Court of Uganda. Judge Sebutinde has received numerous honors and awards for her work, including being honored by ASIL in 2014 with the Prominent Women in International Law Award. I know I join all of you in welcoming Judge Sebutinde to our conference and look forward to her remarks. Judge Sebutinde's remarks will be followed by a distinguished group of panelists, our United Nations 75th Anniversary Plenary Panel. We hope that you'll participate. And as always, if you have not done so, consider becoming an ABILA member and getting involved in the organization. Thank you.
It's both a distinct honor and pleasure to join you in commemorating the 75th anniversary of the United Nations and its principal judicial organ, the International Court of Justice, a court on which I've been honored to serve since 2012. I would like to begin by thanking the American branch of International Law Association, Professor Laila Sadat, and the ILW 2020 Planning Committee for extending such a kind invitation to me to speak on this important occasion. International Law Weekend is such a wonderful tradition, and I'm delighted to be a part of it this year. Consistent with the theme of this year's conference, the theme of my presentation today is the role of the International Court of Justice in challenging times, 75 years on. I'll start with commemorating a few thoughts on how the court started. With the dissolution of the League of Nations in the mid-1940s and the creation of a new international political order, the international community had to carefully consider what role, if any, a world court would have in the post-war era. Unlike its predecessor, the Permanent Court of International Justice, the ICJ would be the principal judicial organ of the United Nations on the same footing as other principal organs of the UN. All member states would also be part to the statutory court. The court's jurisdiction would no longer be compulsory, but willing member states would have the option to accept that jurisdiction as compulsory or on condition. The court would have advisory jurisdiction, but would not have jurisdiction over political issues. Basically, that's the kind of court that the international community envisaged. Now, the achievements of the United Nations over the last 75 years have been unparalleled in human history. Out of the turmoil and tragedy of a devastating world war, the United Nations emerged from the ashes to offer humanity the best hope for the maintenance of international peace and security, for non-aggression and for human rights, for sovereign equality, for self-determination of peoples, and for the rule of international law. These are the foundational purposes on which the international legal system is based. As the principal judicial organ of the UN, the International Court of Justice has played a critical role in realizing the mission of the United Nations. Chapter 6 of the United Nations Charter, which establishes the framework for the pacific resolution of international disputes, states that legal disputes should, as a general rule, be referred by the parties to the International Court of Justice in accordance with the provisions of the Statute of the Court, close quotes. The history of the court shows great progress towards that goal. On this historic anniversary, it's appropriate for us to reflect on the exceptional contributions that the United Nations and its organs have made to the common cause of humanity. In doing so, however, one cannot be blind to the difficult challenges that confront the United Nations and the international legal system it presents. Let me start with the challenges that we face today as the international community. Today, I address you in the midst of a global pandemic that has claimed over 1 million lives globally and has tested the durability of diplomacy, international relations, global economies, and human rights the world over. In addition to novel threats to biosecurity, we are faced with novel threats to cybersecurity and data privacy. Many countries face rapidly evolving forms of global terrorism. Climate change and rising sea levels present existential threats to many island and coastal states and their fish stocks, and pose new threats to human health, security, and economic welfare. Bringing the obligations of corporations into better balance with the far-reaching rights that international law has granted them is yet another challenge that the international community has struggled with in recent times. The international community continues to face challenges to the achievement of long-standing goals such as nuclear disarmament and the realization of fundamental human rights. Our responses to these challenges, which can only be addressed through diplomacy, cooperation, and a redoubled commitment to peace through law, are hindered by the rising tide of nationalism and a wave of antipathy towards multilateralism and international organizations. Truly, international law finds itself in challenging times indeed. Which brings me to the role of the International Court of Justice in the midst of these challenges. So one might ask, what role a court whose jurisdiction is based solely on the consent of states parties and whose decisions have no formal application beyond a specific dispute can play in confronting all of these daunting challenges? Well, the court's history demonstrates that it does play a vital role. Over the years, states and the international community have increasingly turned to the court to address exceedingly difficult and politically sensitive issues. And so states must continue to rely on the court. Now, the court has its limitations in that its jurisdiction is strictly limited to resolving legal disputes that states agree to submit to it, or to giving advisory opinions on specific questions referred to it at the request of international organizations. On this 75th anniversary, however, we can reflect on the substantial growth in the number and type of legal disputes that the court has been asked to resolve over the years. In 1977, the year in which I earned my first law degree, the court issued no judgments. In contrast, this year, 2020, despite a global pandemic, which brought normal working relations to a halt all over the world, the court has already issued at least 2 judgments and at least 5 orders, including a provisional measures order in the case of the Gambia versus Myanmar, which is the subject of one of the panels at this conference. Since its founding, 151 contentious cases have been submitted to the court, and it has issued 28 advisory opinions. 74 states have accepted the court's compulsory jurisdictions, and at least 300 treaties refer disputes relating to their interpretation and application to the jurisdiction of the court. Today, the diversity of the parties in cases pending before the court is remarkable. At the moment, the docket involves parties from the Americas, from Asia, from Africa, and Europe. The court has certainly earned and maintains the title of the World Court. Countries all over the world place their confidence in the ICJ to resolve their disputes. In these challenging times, the court's enduring offer of peace through international law is as important as ever. Now, the court's history shows that by exercising its contentious and advisory opinion, it is capable of handling the most challenging issues of today and tomorrow. The court has been called on to address disputes and questions relating to nuclear weapons, environmental harm, biosecurity, terrorism, and the breakdown of domestic relations, and many other vexing challenges that I have not been able to mention. It has been called on to give better meaning and interpretation to many of the foundational principles of international law. In all these cases, the court has not shied away from its judicial function. First, let me examine a few of the types of cases, starting with cases involving terrorism and armed conflict. Just last year, the court rendered its judgment in the Jallow case, which featured allegations of espionage and terrorism against the backdrop of threats to international peace and security. After the Uri terrorist attack in September 2016, border skirmishes began between India and Pakistan in the Kashmir region, leading to dozens of casualties over a 2-year period. It was against that backdrop that in 2017, India lodged an application with the court, claiming that Pakistan had denied consular access to one of its nationals, that's India's nationals, in violation of Article 36 of the Vienna Convention on Consular Relations. That Indian national was one Mr. Kulbhushan Sudhir Jadhav, a former naval officer who had been arrested by Pakistani authorities, tried and convicted of espionage and terrorism by a military court in Pakistan and sentenced to death. In its judgment ordering Pakistan to grant India consular access to the prisoner and to review and reconsider Jadhav's conviction and death sentence, the court demonstrated that allegations of espionage and terrorism do not suspend consular obligations of states under the Vienna Convention. The court's judgment did, however, reveal some of its limitations. The court could not accede to India's request that it annul Jadhav's sentence and order his release. That was going too far. The court's duty was to interpret and apply the Vienna Convention, the treaty on which its jurisdiction was founded, not to sit as a Supreme Court of Criminal Appeals. So even in the midst of terror-related hostilities, the court's judgment reaffirmed the obligations of states in the Vienna Convention on Consular Relations that are fundamental to friendly diplomatic relations between states. The Jadhav case was not the first time that the court has helped to resolve a dispute involving allegations of terrorism during times of strained diplomatic relations. You remember in the Lockerbie cases, the court upheld the supremacy of Security Council Resolution 748 of 1992, calling upon Libya to extradite 2 of its nationals suspected in the tragic bombing of the Pan Am airliner over Lockerbie, Scotland, which claimed 279 souls. In 1979, the United States turned to the court for help to resolve the Iran hostages crisis, which involved allegations that Iran had sponsored terrorist attacks against the US Embassy and its staff. Although Iran did not immediately comply with the court's judgment ordering the immediate release of the hostages, the judgment in that case was influential in mobilizing international public opinion in favor of the political settlement that followed. Now, as states continue to grapple with the challenges that terrorism poses to international peace and security, the compromissory clauses in the Convention for the Suppression of Financing of Terrorism gives them the ability to turn to the court to help resolve these disputes, such as in the case of Ukraine against Russia in 2017. Now, the Jallow case was not the first time that states have turned to the court to resolve disputes that were overshadowed with armed hostilities between the disputing parties. In Libya versus Chad, and in Burkina Faso versus Mali, in Cameroon versus Nigeria, and in the Temple of Priya Vihia cases. All are examples of territorial disputes that featured armed hostilities, either immediately before or during the proceedings that the court resolved. Which brings me to cases involving threats to the environment and to biosecurity. States have also turned to the court to resolve disputes involving threats to the environment and to biosecurity. In pulp mills, for instance, Argentina accused Uruguay of authorizing construction of a pulp mill that polluted the Uruguay River in violation of a treaty between the two states regarding the protection of the river. The court ultimately rejected Argentina's claim, but in its reasoning, it recognized that the performance of an environmental impact assessment is now an obligation under general international law, where there is a risk that the proposed industrial activity may have a significant adverse impact in a transboundary context. Similarly, in the joint cases between Costa Rica and Nicaragua concerning the construction of a road and the dredging of the San Juan River, the court reaffirmed the obligation to conduct an environmental impact assessment whenever and wherever there is a risk of significant adverse environmental impact in a transboundary context. And the court also made clear that the scope of the assessment must be consistent with international standards. The court in those cases found that Nicaragua had unlawfully caused environmental damage in Costa Rican territory and awarded Costa Rica monetary damages for the environmental damage to the ecosystem as a whole. And they also ordered restoration costs and other costs and expenses. Now, cases involving threats of nuclear weapons. The court's decision in the various nuclear tests cases also demonstrates its ability to help states resolve disputes even when the gravest question of global and biosecurity are at stake. In 1973, for example, Australia and New Zealand turned to the court to resolve their dispute with France concerning atmospheric nuclear weapons testing with alleged radioactive fallout over their territories. Although France boycotted the case, it would be wrong to say that its commencement had no effect. It certainly played a role in France's decision to end the tests during the pendency of the proceedings, rendering the applications moot. And of course, in its 1996 advisory opinion, the court firmly established that the use of nuclear weapons is not beyond regulation of international law. More recently, the Marshall Islands turned to the court to seek compliance of 9 different states with their nuclear disarmament obligations. Although the court declined jurisdiction in those cases, it is significant that states find it worthwhile to still come to the court with such important questions that concern the survival of humanity and of our planet. Now, there are those persistent challenges relating, say, to decolonization and to self-determination that the court continues to grapple with. So the court also continues to help the international community address persistent challenges that predate the United Nations. The UN and the court have been highly influential in the decolonization process. The court's advisory opinions and judgments in the cases related to Namibia and the Western Sahara were instrumental in giving effect to the right to self-determination. That peremptory norm of international law guided the decolonization process and gave birth to so many new states that subsequently took their rightful seats in the United Nations General Assembly. The court's decision in East Timor and its advisory opinion concerning the construction of a wall in the occupied Palestinian territory played an important role in further shaping the right to self-determination and the human rights that go with that right. However, 60 years after the declaration on the granting of independence to colonial countries and peoples, the completion of the decolonization process remains a challenge with which the international community is faced. In the Chagos advisory proceedings 2 years ago, the international community once again turned to the court for help facing that challenge. The General Assembly requested an advisory opinion from the court on the legal consequences of the United Kingdom's separation of the Chagos Archipelago from Mauritius prior to Mauritius attaining independence in 1965. In its advisory opinion last year, the court concluded that the right to self-determination must be exercised in relation to the whole of the territory of the non-self-governing peoples, and that consequently, the decolonization of Mauritius was not completed, despite its independence in 1965. That opinion gives the General Assembly and the international community greater legal clarity to one of the UN's longest standing goals, namely the decolonization process and the right to self-determination. Now, looking forward, the court cannot see international law through these challenging times alone. The jurisdiction of the court is limited, as I've pointed out above. Many of the most perilous disputes and frustrating legal questions will probably never make their way to the Peace Palace. And when they do, states may decide not to comply with the court's judgments. However, I do not only see the challenges, I also see promise. Our responses to all of the new challenges we face, and the old ones, must be informed by the ever-evolving rules of international law that have brought so much peace and prosperity over the last 70 years of the United Nations. All of the cases that I've discussed above show that the court has repeatedly helped states to resolve bitter disputes and help the international community address challenging questions in challenging times through international law. The challenges before us may be different, but the role of the court is the same: to contribute to world peace and security through the rule of international law. In our quest to truly become a community of nations and to uphold the international rule of law, we should remember that the provisions of the Charter establishing the court were the first to receive full approval at the Conference of San Francisco. We should remember the words of the president of that conference when he said that no peace and no true fraternity could be reached among the peoples of the earth unless it was based upon that justice of which the court is the very symbol. The challenging times we face call for an increased commitment to that notion of justice, and indeed its pursuit through the jurisdiction of the court. I thank you all for your kind attention, and Godspeed. Stay well and keep safe.
Good morning, everybody, or good afternoon, or good evening. Thank you so much, Judge Sebutinde, for that fantastic opening keynote address for our celebration of the 75th anniversary this morning of the United Nations Charter. I'm going to play a very short video. I know we have many, many students in the room, I wanted to say, in the Zoom room. And I think sometimes a picture is worth 1,000 words. And before our panelists convene, you will watch a short historical documentary on 2.2 minutes. So grab a cup of coffee and it won't last very long. But it ties in nicely to Judge Sebutinde's remarks about the history of the San Francisco Conference and the ultimate signing and ratification of the Charter. So please hang on. I will hopefully share my computer sound and it will work. I'm sorry if you had problems with the sound. I was able to turn it up and I hope you were too. If it's now too loud, feel free to turn it back down. So without further ado, short historical video on the signing of the United Nations Charter, after which time we will convene our panelists and open the discussion.
American History TV's Real America brings you archival films that provide historical context for public policy issues of the 21st century.
Here in the midst of war, the world's people collaborated in the drafting of a workable international constitution. It was a conference to write a people's charter, opening with the words, "We, the people of the United Nations, determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind." It was a people's conference and a soldiers' conference, meeting under the eyes of veterans of 2 wars and the generation which must suffer if the Constitution fails. Common people and their governments alike were aware of the stakes.
There were many who doubted that agreement could ever be reached by these 50 countries, differing so much in race and religion, in language and culture. But these differences were all forgotten in one unshakable unity of determination to find a way to end war.
This charter points the way. But whether the world is to move in that direction will depend finally upon the vigilance and sovereign will of the peoples of the world.
All right, I will ask our panelists to convene, please. Good morning, and hopefully my volume is not too loud. Please adjust yours if it is. I know some of you are having trouble hearing the fine judge. So in thinking about this panel today, by the way, I should introduce myself. I'm Layla Sadat, president of the American branch of the International Law Association and a professor of international law at Washington University in St. Louis. In thinking about the panel, I was thinking not only about the history of the United Nations and Judge Sebutinde's keynote address, but some of the discussions I heard during the weekend. Ambassador David Sheffer reminded us during the opening plenary that we've seen an evolution of the world's peoples through the ages and divided it into an age of alliances, an age of collectivism, an age of multilateralism, an age of superpowers, an age of isolation, and our current age, the age of collaboration. And he had challenged us in his opening address with the idea that the governing generation's challenge is no longer to change the world, but to save the world. As we gather virtually through the extraordinary gift of technology, and thank you again to Arbitration Place, our host, I've been struck through the weekend at how technology has brought individuals from all over the world to our meeting this year. I've really missed the opening reception in the stuffy rooms of the New York City Bar Association. I hope we'll be back next year. I've missed the opportunity to meet old friends and new at Fordham Law School, our usual home. And if the truth be told, I've missed the glass of wine, the great food, the terrific shopping in New York City, and the camaraderie of friends, including their hugs. But I've also appreciated how through the miracle of Zoom, technology has brought together a law professor from Khartoum, a human rights activist from Colombia, a business person from Paris, a law student from China, together to listen and to interact. And so I do think Ambassador Sheffer was right when he called this the age of collaboration. In a way, it's the era of the network, and we can use the network to bring us together, just as others, of course, can use it to drive us apart. We always have a choice: division or cooperation, justice or injustice, law or chaos. It only seemed fitting, given the theme of the weekend is the challenge of international law, to have the opportunity to celebrate United Nations Day during our 99th members meeting and plenary panel. 75 years is a long time for an organization to survive, and despite the challenges, the organization has much to celebrate. Catherine Amerfar spoke of bipartisanship in her remarks yesterday, and I note the little video you saw was an American information video, and when the charter was ratified by the United States Senate, the US was the first country to ratify on July 28, 1945. The vote was 89-2, and the organization had tremendous bipartisan support. Harry Truman, the new president from my adopted state of Missouri, who became president upon the shocking death and sudden death of Franklin Roosevelt, understood he needed Democrats and Republicans, and he got them. Although the organization has had many ups and downs since 1945, to quote another famous Missourian, Mark Twain, I do believe the reports of its death have been greatly exaggerated. Here to discuss the progress and challenges of the institution are four superbly qualified individuals, and I'll just introduce them very briefly because otherwise it would take all day. First, Larry Johnson. Mr. Johnson was formerly Assistant Secretary General for Legal Affairs in the UN. He spent his career as a lawyer in UN organizations, including the International Atomic Energy Agency in Vienna, and as chef de cabinet for the president of the ICTY in The Hague. He has taught at Columbia Law School, many other institutions, including Washington University in St. Louis, my own school. Then we have Ambassador Christian Vanevaser, who has been the permanent representative of Liechtenstein to the United Nations since 2002. He's been particularly active in his role as chair of the ICC Special Working Group on the Crime of Aggression and as the president of the ICC's Assembly of States Parties. Patricia Galvao-Telege is a professor of international law at the Autonomous University of Lisbon. She's also an adjunct senior research fellow at the Center for International Law of the National University of Singapore and co-director of the Singapore Academy of International Law. She's a member of the International Law Commission and chair of the study group on sea level rise in relation to international law. She's also a member of the Permanent Court of Arbitration. And last but certainly not least is Charles Jallow, a professor of international law at Florida International University in Miami, a member of the UN International Law Commission, where he was elected by his colleagues as chair of the drafting committee for the 70th session, and as the general rapporteur for the 71st session. He's also the founding editor-in-chief of the African Journal of Legal Studies and the African Journal of International Criminal Justice. Professor Johnson has suggested he might begin by talking about the history of the drafting of the charter, which can then give us a nice segue into how it can continue to respond to today's challenges and what might be needed to enhance popular support for its activities and its ability to perform its functions. So without further ado, Larry, I give you the floor.
Great. Well, thank you very much. It's a great pleasure to be here. And thank you, Layla, for having that video intro. In fact, it's a nice platform for me to start. And also I heard that there was it was an interesting and fun evening last night with a trivia contest. So in fact, I'll begin with some of the trivia. In that video, if you go back and look at it, if you can, or find it, you'll see, I think, a young looking person on the left whenever you had heads of state or government signing the charter, including when Truman was there, but others as well, a sort of dapper looking fellow. And that person was the Secretary General of the, it was called the United Nations Conference on International Organization. And that person was one Alger Hiss. And speaking about cooperation between the parties and bipartisan support of the UN, of course, Roosevelt had made sure that Republicans were very much involved in the drafting and at San Francisco. But it was, of course, only later that Alger Hiss was accused of being a Soviet spy. This fed into the McCarthy period. And in fact, the State Department people that helped Alger Hiss in organizing the San Francisco conference were they were the prime targets of investigating what had happened. So it's interesting that, and one of the, as a trivia point, in 1995, when you had the 50th anniversary, and there was to be a celebration in San Francisco to recall what had happened 50 years before, the question is, what do you do with Alger Hiss? Do you invite him or not? So, not exactly a legal question, huh? But in the end, Alger Hiss was still alive, but he was blind and in ill health. And there were still, he had always proclaimed his innocence, that he had been a Soviet spy, and that had helped Richard Nixon proceed in his political career. In any event, they checked with him first, and he said he would not be able to make the trip to San Francisco. So they did go ahead and invite him, because apparently he was absolutely instrumental. And I knew someone who had been in San Francisco as a stenographer. She had been a United Airlines stewardess and had been on planes between San Francisco and Denver or Chicago with the State Department crowd. They talked her into being a stenographer or a secretary. And she said Alger Hiss was an amazing organizer, and he would have been the first Secretary General, except he was an American. In any event, let me go, I digress, but your video sparked that memory. So often the way I start talking about the history of the Charter is to ask another trivia question, is who was the vice president, for you Americans out there, who was the vice presidential candidate in 1920? Who ran with one Mr. Cox, I think James Cox, governor of Ohio, on the ticket, and lost badly because they ran on a ticket pro-League of Nations, pro-international organizations, and that was one Franklin Delano Roosevelt. Roosevelt had been Assistant Secretary of the Navy in World War I. He was a very strong Wilson supporter. And he was very much engaged in military strategy. And he was not a member of the military, but again, Secretary of the Navy, Assistant Secretary of the Navy. And he all along believed that international organization had some role to play in maintaining peace and security. Of course, he kept, once they were defeated badly in 1920, as he proceeded with his career, he got polio later in the 1920s after the campaign, but he was a very vigorous campaigner, again, for the League. He remembered that. And once the League failed in the 30s to stop fascism, he instructed his State Department people to start devising some alternative, not to reform the League, that had failed, and it wasn't going to politically fly, given what had happened in the US Senate in the League. So he said, fix it and try to make it a more effective collective security organization. And also don't make it so legalistic, all you lawyers. He considered that the League of Nations covenant was too legalistic, sovereign equality and all of that. What we need is realpolitik, realism. So those that had fought the war and were fighting the war at the time would be those that would organize the peace. So the one thing that you need to bear in mind, this thing called the Charter was basically written in the State Department. Don't tell anybody in the White House today, but this is basically an American product that had then, which was then floated to the Soviets and the Brits in various conferences in World War II. And the name of the organization is actually a name which during the war meant allies. You had 3 weeks after Pearl Harbor, you had in January 1st or 2nd in Washington, the United Nations Declaration, which was the 20-some odd countries that had declared war against Nazi Germany, fascist Italy, and Japan, giving their war aims. So the term United Nations throughout the war meant allies. Indeed, some of you involved in international criminal law will recall the United Nations War Crimes Commission. It had nothing to do with the organization. It was allies. It was an allied clearinghouse for looking at domestic charges against the atrocity crimes that we all know so well. So anyway, it's a wartime organization. Roosevelt also wanted to make sure the conference was held during the course of the war. He thought one of the problems in 1919 was that conference in Versailles was after the war and got mixed up in peace treaties. So he wanted to strike while the iron was hot. So they decided who would be invited to San Francisco? Only allies. No Sweden, no Switzerland, no Ireland, certainly no Spain or Portugal. They were not welcome. They were not allowed in. You had to have declared war on the Axis powers in order to be invited to San Francisco. And you see various parts of the charter. And why go into all of this is to understand, in some ways, it's like constitutional law. The charters, I think, I would agree with Tom Frank and others, the late Tom Frank, that it is a constitution. You have to see what was around the context in which it was drafted, and that helps explain. So the idea was that the big three, and then they added China. France only came later in San Francisco. De Gaulle was miffed because he was not invited to Yalta. So he refused to become a co-sponsoring government of the conference. So the conference was sponsored by the US, the UK, the Soviets, and the Chinese. And it was held about 2 weeks after Roosevelt died, as you mentioned, Leila. And at some point at that point, there was a question whether to proceed with the conference. But Truman said, no, let's go ahead with it. It's I think he died April 12th and it began April 26th. So it was pretty quick. So a lot of the conference was in honor of Roosevelt, who was really the father of the whole thing. But it was during the war. It began before the surrender of Hitler, which came about a couple of weeks later in early May. But the war in the Pacific was raging. So in San Francisco, as the video showed, they saw the sailors and the soldiers coming back from battle. And they read about the battles in the Pacific. So the war was very much alive and in their minds. And the whole idea of a collective security system where the major powers, the allies, would stay united to preserve the peace. That was in their minds. So in the charter, you have all kinds of things which, after several years, never happened. They were never implemented. But the idea was to have a collective security system where you'd have a UN army. And that would be, and it would be run similar to World War II, where you have a joint allied commanders, but this would be the military staff committee, the 5 permanent members. They're chiefs of staff, not the politicians, not the diplomats, but they're military, would meet in the military staff committee and conduct a war against another Hitler or another Mussolini or another Japan. And in fact, you had some, up until the middle of 47, you had the 5 permanent members indicating how many troops they would contribute to the UN army. And you had a military staff committee report which goes through that and indicates, for example, the Americans would provide 1,250 bombers, the Soviets 600. In terms of ground forces, the US was willing to put in 20 divisions into the UN army, the Soviets 12, France 16. You had submarines, the US was willing to put 90 submarines at the disposal of the UN army, and the Soviets 12 and everybody else 12. So you see that the disconnect politically between the power of the United States at that time. It was the only one that had really not been invaded and not suffered, at least, clearly not suffered as much as the other allies. So in there, they developed, the military staff committee developed principles for the UN army, which in fact have informed the peacekeeping operations. But in it, it said that the permanent members would be the ones that primarily put troops and personnel into the UN Army. Up and the three Westerners in China said up to the capabilities of the permanent member. The Soviets said, no, it's got to be the same amount per permanent member, because otherwise, as the Soviet quite rightly pointed out, it would be an American army. Because the Americans were the only ones that had all the men and the equipment to be able to muster a real UN army. In any event, that is behind the idea of collective security. And I just wanted to mention that to give you a context of why the Charter reads as it does. You have enemy states provisions that are in there that preserve the right of the Allies to take action in case there was a resurgence of Nazism or fascism or militaristic Japan. But there is one thing, Layla, I'm not sure if you've heard it, but there is a rumor these days that World War II is over. So now what do you do? So that's in part what we're here to talk about, because many provisions, or a good number of the provisions of the Charter have been adjusted by practice, just like any constitution. Right away, they did away with the concept of a concurring, that everything out of the Security Council of substance needed to have the concurring votes of the permanent members. In normal English, concurring means you agree, you concur. But right away in the second year in the Security Council, a permanent member abstained. And right away they said, no, that's not to be counted as a veto. So from the very beginning, there have been adjustments to the text to adjust to what is needed. So the challenge today is, of course, how to adjust the Charter from that period, the wartime document, how it can deal with current challenges, and what do you do with a system that is built on realpolitik, where everybody's equal, but some are more equal than others. And you have the veto system, and how do you either adjust it? How do you modify it? How do you get gentlemen's agreements? I mean, they were not stupid in 1945. The amendment provision would require the agreement of all 5 permanent members, and not just an abstention. They need to ratify an amendment. So they would need to agree to any textual change in the Charter like the veto. So maybe I should stop here. But anyway, that's sort of the historical background, the foundation. But there were lofty goals. I don't want to diminish that at all in terms of sacrificing for realpolitik. It did begin with we the peoples, and it did include provisions which we've seen and we'll discuss, the great successes of the Charter that they did not foresee in 45. Human rights, international criminal law, peacekeeping, all of that. But let me stop here, Layla. Thank you.
Thank you, Larry. And for those of you who want more, I do believe Professor Johnson teaches entire courses on this, as you can tell. Fantastic way to start us off. So Christian, fast forward, it's 2020. You're right in the thick of it, trying to make this historic document work. Tell us about your part of that job.
Thanks a lot, Layla. I hope you can hear me.
Mm-hmm.
Good morning. Good morning, everybody. Great pleasure to be here on UN Day, and I think it's enormously important to go back in time to get the historical perspective. We did, in fact, yesterday a seminar on the role of the right of self-determination in the history of the United Nations over these past 75 years, and we did the same thing. So we looked both at the history of this, in particular, of course, in the context of decolonization, but also then in the forward-looking way. And we asked ourselves, how can it be applied? And we found enormous potential in it. But listening to Larry and also looking at the short video. Where we came from, because this is also has to guide us in where we are going. Now, certainly the first thing to say today is that at a time when past achievements are very much questioned back, and that time when approaches that we thought were not questioned a few years ago are in fact on undermined and attacked, and in particular the principle that we all work together, impact and ramifications. So today is certainly a very important moment to say that, you know, the Charter of the United Nations is one of the finest moments of multilateralism and of international diplomacy. We are a state that is very, very small. We're one of the smallest members of the United Nations. And in part due to that, but not only, we are very strongly committed to the rule of law. And we have always, in our 30 years of membership in the United Nations law, at the heart of what we try to achieve in this organ. I'll talk a little bit about our activities. We did have a celebration here in New York in this imperfect format also that we're all getting used to on the 21st of September. We did have a summit meeting to celebrate the 75th anniversary of the United Nations, and that meeting did result in, first of all, the adoption of an outcome document that does recommit all of us to the UN Charter, and also brought very strong messages in support of multilateralism and of the United Nations, a message that is politically really of the highest possible relevance at this particular moment in history. But let me talk about some of the aspects of the Charter, some of the aspects of our particular work here as a mission, and then some of the broader challenges that we are facing. Larry has made it very clear to what extent the UN Charter has been a living document, to what extent its application and its interpretation has evolved over the years, and we certainly continue to see enormous relevance and potential in the Charter to address current challenges. One of these challenges is, in fact, pretty much the founding purpose of the United Nations. If you listen to the video carefully, and that really got my attention, the sentence that stood out for me was, "We came here together to find a way to end war." And that was the very purpose of the founding of the United Nations. Now, in my view, we have, in our daily work, I think we have deviated from that purpose to a significant extent. I think the Security Council, in a very limited way, sees its role more as far as managing armed conflict and managing wars, and not so much as ending wars. So I think we have lost a little bit sight of that, and I think we have to regroup and refocus on that very purpose. If you look at the Charter of the United Nations, you will find that the use of force is clearly regulated in the Charter, and the use of force between states is limited to only two instances, and one is where the United Nations Security Council authorizes the use of force under its Chapter 7 of its Charter, and the second is if a state acts in self-defense under Article 51. These are the two instances in which the use of force is legal under international law, and all other instances are not. This is a very narrow scope, and it's certainly not what we see in the practice today. What we find particularly worrisome is the development with respect to the use of Article 51, self-defense, and the manner in which the self-defense is invoked by states, and that happens in a way that is not checked by the Security Council or by the rest of us. So a state or states, a number of states have simply said, I'm invoking Article 51, this is why I did this, that, and the other. In some cases, pretty much, at least prima facie, not in accordance with international law, but no conversation on that followed up, no action followed up in the Security Council, not even among us states. So we have to reassert, as the sovereigns that we are, we have to reassert the provisions of the Charter and say, wait a minute, can we talk about this? Because this is not what we think the Charter of the United Nations says. You have mentioned my work, Leila, that I've done on the in the framework of the International Criminal Court. This, of course, is a complement to this, because what we did at the Kampala conference when we adopted the amendments on the crime of aggression is, in fact, we complemented the Charter of the United Nations by creating individual criminal responsibility for persons in leadership position who are responsible for the most serious violations of the UN Charter as far as the use of force. So individuals that are in a position to plan or control acts of aggression against the state. So this is what the Charter has said since 1945. And since 2017, we now also have the possibility of not just saying this was a violation of international law, this was a violation of the UN Charter, but also to say, and person XY is individually responsible for committing that crime. The second area I wanted to flag briefly is the question of cyberspace and the application and the regulation and the governance issues in cyberspace. You know that this is a very, very complex area that has both an enormous potential and comes with enormous dangers. And the question, of course, is what rule does apply out there? We have come to the conclusion that international law as it exists does apply in cyberspace. We have been able to find the consensus on that. That sounds like a very bland and a very general statement, but I think it's an enormously important statement that gives us simply a basis for what we need, because we still have to sort out what does that exactly mean in practice and which law does apply in which way exactly. And in this area, again, we have built on our expertise with respect to the use of force and are looking in particular at the question which acts committed in cyberspace, and there are many that are directed by state against state, qualify and do fall under the international definition, and then also entail a check that is both, I have to say, extremely exciting and inspiring and intellectually challenging and politically complex and difficult. We are about to finalize the first phase of this, and we will publish our first report on this towards the end of the year. The third area I wanted to flag is the role of the Security Council and what comes with it. For many people, for better or worse, the Security Council is the center of the UN system, which I may or may not agree with. That's not the point here, but certainly there is no question that the Security Council is the body that gets the most international attention, the most media attention, and comes with the biggest expectations. It is the body that was created to be the guardian of international peace and security, an enormously big and important task. The Security Council is increasingly unable to carry out these functions. If you look at the conflicts around the world, the most obvious or the example usually quoted these days is, of course, the conflict in Syria that has been going on for almost a decade. In March 2021, it will be a decade under the supervision, I shouldn't say, but without the ability of the Security Council to intervene to any effect. So this has led not only to untold human suffering, to the use of internationally banned weapons, chemical weapons. It also has destabilized an entire region and has turned into regional conflict with international involvement. And the Security Council has been blocked by the use of the veto as far as making meaningful decisions in Syria 13 times. And that illustrates both the political dynamic in the Security Council, and it illustrates again the negative role that the veto has been playing in the role of this organization. Larry has talked about it very briefly. He has touched upon the question whether an abstention is a veto, which it isn't, or was probably meant to be in San Francisco, but in practice was very quickly ruled not to be. But the reality today is, of course, that you have the major powers in the Security Council that are politically very much at odds, be it the US and China, be it the US and Russia. And all these states do have the power to block any decision in the Security Council. Now, the veto is not, we cannot do away with the veto. Larry has also mentioned not in much detail, but clearly the fact that the Charter of the United Nations is certainly in this respect pretty much unamendable, in my view, because the veto can only be eliminated if the permanent members themselves give it up, which I think is not very likely to happen. So what we have been trying to do is to work in the framework of the existing provisions of the Charter. That means to accept the fact that there is the veto, but to ask for ways in which it is applied and for commitments from the permanent members not to apply it in a manner that in our view is contrary to the Charter itself and contrary to the purposes and the principles of the Charter itself. And we have done two things in this respect. One is a finalized product, one is a product in the making. We have written a code of conduct which commits states, if and when they serve on the Security Council, not to vote against a resolution that is submitted in order to prevent or end mass atrocity crimes, such as committed in Rwanda, such as committed in Srebrenica, in the former Yugoslavia. And we, as Liechtenstein, we have made a support of this code of conduct a precondition for our vote for anyone who runs for the Security Council. We have 123 states that currently support this code of conduct and are committed to it. And that is a very good progress. It's, of course, not all the permanent members, for example, that have signed on to it, because there are a number of permanent members that do not believe that the veto should be subject to any modifications, conditions, discussions even. But we have France and the United Kingdom that have signed on to it, along with 121 other states. And it's also something where public opinion, in my view, can play a very important role. The second thing that we are working on right now is a pretty, in a way, simple but politically very important measure, namely to say every time a veto is cast in the Security Council by whomever and on which text ever and for whatever reason, that the General Assembly convenes automatically to discuss the situation and to discuss the veto that was cast. So we believe that is an extremely important accountability measure that will allow us to manage the competencies and the powers between the main organs, namely the General Assembly and the Security Council, in a more productive manner. Thank you so much. I hope I haven't been too long, Leila.
Thank you so much. That was just perfect. And you actually answered one of the questions in the chat about cyber war, but if you could put into the chat information about when your report will be distributed, because there was a question about that. Now I'd like to turn to Professor Patricia Galvao-Teles to talk about the United Nations as a global forum and some of the issues that have been raised. Patricia, it's for you now.
Thank you so much, Leila, and it's really a pleasure to be again part of International Law Weekend. As you say, I would certainly have preferred to be in New York together with everybody and with the participants, but this is what we have now, and I think it's very important that we keep the discussion going on and that we don't stop having this kind of events, even if we have to do them in this new format. So I wanted to speak about the UN as a global legal forum. I see that the previous two speakers have focused particularly on the questions of peace and security, both from a historical perspective and also a very up-to-date overview of what's going on in the UN and the challenges. But I wanted to take a little bit of a different approach and focusing on one of the areas where I think the UN has given a lot and has really generated an important forum, as I call it, a global legal forum for lawmaking, for a negotiation, for dispute settlement. So I think for me, it's from my point of view, it's one, besides of all the work of the UN in peace and security, human rights and development, the traditional three pillars of the organization, this role as a global legal forum has been one of the greatest achievements of the UN in the past 75 years, and that it needs to be highlighted. And at the end, I will address a few future challenges also from this perspective. So I think what we can see in the past 75 years, and especially comparing to what we had before in the period of the League of Nations and before that, is that international law has developed exponentially in terms of quantity, quality, areas that are touched. It's really something that is a big change from the period before the UN. And it's something where certainly the UN had a catalyzing role, an accelerator role, and that would not have been possible if it wasn't for this forum where states, big, small, initially a smaller number of sovereign states, and after decolonization, a much larger international community could come together to put together their concerns in very different issues with regard to international lawmaking. And this has happened not only in the more traditional areas of international law, but also in new areas where also the organization has shown that it could adapt to new challenges and more specialized areas of international law. I think it has already been said by other speakers, and I think the video was quite interesting already at that time, calling the charter a constitution. I think that's quite important, and I agree with what has been said already before, that really the biggest contribution of the UN was the creation of the charter, and in particular outlining the fundamental principles of international law in Article 2 that were then later completed in the Friendly Relations Declaration that is also this year commemorating 50 years. That's been an incredible contribution, of course, stating the existing principles like sovereignty and non-interference in domestic affairs, but new principles, very important, like the prohibition of the use of force, but also self-determination and human rights. But it also has given a lot of impetus in codification of traditional areas of international law that today maybe we take for granted, like diplomatic relations, consular relations, or the law of treaties. I mean, any student of international law has come across these products, and it's really been the work of the UN in the codification, and in particular through the initial input of the International Law Commission. And I'll come back to the International Law Commission in a bit. But I think the UN has also realized that there were new areas that needed development, and it has managed to come together and its member states in the General Assembly and other forums related to the UN to create a whole new regime for human rights, for the law of the sea, for environmental law, and for climate change law. And I think these two last points were two areas that were completely unforeseen when the charter was being negotiated, and now they are at the core of the work of the organization, and the very important treaties that have been adopted are at the moment what we have in terms of legal tools to protect the environment and to fight climate change. Of course, the lead actors in this international lawmaking process in the UN as a global legal forum are mainly the General Assembly. And I think sometimes, and it was just said by Christian, the Security Council is the UN organ that gets all the attention. But I think the General Assembly has also a very important role, not only because it has all member states participating with an equal vote and there's no veto, but because it has really taken up this challenge of building up and developing an international legal order, and together in the Sixth Committee in particular, with the inputs of the International Law Commission, but also in other committees that have also witnessed negotiation of international conventions. But not just thinking about the General Assembly. I think we have also to look at the whole system of dispute settlement. And I think that Judge Sebutinde's remarks that preceded our panel were very interesting to highlight how busy the International Court of Justice is nowadays. So part of this global legal forum, I consider also international courts and tribunals that have some kind of connection to the UN. And certainly it's the case of the ICJ, which is the principal legal organ of the UN. And the case also of ILW, which was created by United Nations Convention on the Law of the Sea, but also the International Criminal Court that came out of a process of negotiation within the within the United Nations, and in particular the General Assembly. So we have today a network, a wide network of dispute settlement institutions, and it's interesting to highlight that although one hears that multilateralism is in crisis and that the UN is losing a bit of its protagonism, the international courts and tribunals have never been busier than now. And that's something that it's quite striking contrast, for example, with the period of the Cold War, where was a big moment of crisis that the UN experienced. I think crisis is not a new word for the UN. The UN has lived in crisis permanently. So I think it's something that we just have to unfortunately take for granted and just find ways for working under those crises and under those challenges. But it's striking that during the period of the Cold War, I think Judge Sebutinde mentioned that the year she finished law school, there were no cases in the international court. And this year, there's been already a few decisions, there are cases coming up. But also if we take this more broader look at ILW, ICC, and also at the PCA, where there are many Annex 7, UNCLOS Annex 7 cases that are going to the PCA, we see that international courts and tribunals are quite busy these days. I'm not going to refer to what sometimes is called as the Security Council as world legislature. That was something that we talked a lot about a few years ago. Now I think that is not appropriate anymore, but still, I mean, it's important to note that the Security Council also has in the past taken some initiatives like creating the ICTY and ICTR, or adopting this very comprehensive resolutions on terrorism or nuclear proliferations that made people talk about this function of the Security Council as a legislator also. So what do we have? I mean, we have a lot of past achievements, and I think it's important to highlight because certainly the international legal order is much different and much more comprehensive and complete today than it was 75 years ago. What are the future challenges ahead? And I will just highlight two, because I know that we're a bit short for time and I want to listen to Charles and also leave some time for discussion. But for me, I think there's, if I can simplify it, there's for me two big challenges. One challenge is the question, the dilemma between a choice between hard law and soft law. We see that there is more resistance into entering from states into entering into new treaties. There's a certain pushback or lack of appetite. People call it different things. But for example, when we think about a potential convention on crimes against humanity, which I know it's one of Leila's favorite topics, we'll see how it goes if we really can make it into a convention. The only big example of an intergovernmental negotiation going on at the moment at the UN is the BBNJ. And there's been a certain preference in certain areas for soft law instruments like the Global Compact for Migration or for refugees. So I think there's a dilemma here. And for me, it's one of the challenges in international lawmaking at the UN. For the near future. And the other one is how the United Nations and the international community are going to try to tackle the pressing challenges of our time, including on climate change. Of course, we have already a regime, especially the Paris Agreement, but there are issues like the one I'm dealing with in the International Commission, sea level rise, and the impacts on international law, how we're going to deal with that. Legally, or other issues like cyber security that was already mentioned, and even pandemics, which the current crisis with COVID-19 has really shown that maybe we need a more strong legal framework to deal, if not with this pandemic, at least with the next one. So I'll stop here and I'll look forward to our discussion. Thank you so much, Leila.
Thank you. So much to think about. And Charles, you now need to pick up the ball and tell us more about your work and the challenges facing the United Nations. And I think you were going to also talk about some of the African initiatives as well. So passing the baton to you.
Thank you so much, Leila, and thank you to the American branch of the International Law Association for putting together an excellent conference. It is, of course, a big honor for me to join friends and colleagues like Christian, Larry, and Patricia on a panel. We all miss New York. I always look forward to the colors of the fall. I live in Miami and we don't get the fall colors, but this is the best we can do right now. So I agree completely that it's important that we continue to have these conversations. In the roughly 10 minutes that I have, and I'm going to try to compress a little bit, I'd like to reflect on the 75th anniversary of the UN from this perspective of international law, both to celebrate the UN and also to critique it. In celebration, I want to share what I consider the most significant impact on African states and African peoples that we've seen in the last 75 years. I'll focus in particular on the role that the UN has played to accelerate the process of decolonization and the recognition of and subsequent exercise of the rights of African peoples to self-determination. While that process in many ways remains incomplete, if you think about the Chagos Islands issue that Justice Sebutinde alluded to in her keynote, it is substantially complete. And judging by the progress we made and the February 2019 findings of the ICJ in the advisory opinion, I think it's only a matter of time that we will complete that effort. On the other side of the ledger, the more critique side, again from the perspective of African states, I asked the question whether it has the scope to achieve even more in terms of the effectiveness of the United Nations. And I'll come back to this point from the perspective of a point that has already been raised by all the speakers, and this is the issue of the role of the Security Council, and whether there is, in fact, more that could be gained by the international community if we engage in Security Council reform, and we take Security Council reform seriously. And obviously here, Christian, a few minutes ago, talked about the current situation where the Security Council seems to understand its own role, as he put it, I think, to manage conflicts rather than to end conflicts. This suggests that this vision of Security Council reform and the kinds of initiatives that Liechtenstein and a number of other states are undertaking at the moment to try to get more out of the Security Council. It's a shared vision. That's not just a vision that African states are wanting a seat at the table, that in fact we could get better out of the organization. And I think this is something that Larry spoke about as well. I mean, he said, I think, how do we adjust the charter to meet the realities of the today, right? Of today, if you think about this as a constitutional document, including perhaps dealing with the aspect of the veto. And I'll come back to that towards the end. But let me just go back to where I wanted to go in the most of my remarks, which is to say, there's probably no better example in terms of what the UN has added for African states and African peoples than the role it has played in the process of decolonization and the realization of the right to self-determination. That road has not always been a smooth one. It was characterized by windiness. We have the context of the Cold War, the push and pull of the forces at play in New York. But the bottom line is it represented that site for global action for oppressed African peoples and other colonized peoples to essentially realize the promise of the Charter. There we see, and I follow nicely here, I think, on Patricia's idea of a global legal forum. We see a number of things. And let me just set a bit of context on that. First, of course, when we talk about 1945, you're talking about a world that had about 750 million people, okay, which is about a third of the population not being at the table, okay? You had countries that did not enjoy sovereignty. They did not govern themselves. They did not have the full control over their political and economic affairs. And literally, we are living through these ideas of the 19th centuries that there were savages that need to be saved, that needed to be civilized. As a result, their countries did not have legal personality under international law. Others spoke for them, decided for them, and apparently even looked after them. Now, starting at least with the famous Berlin Conference in 1884 and 1885, where Africa was literally carved up by European powers, Africans had been pushing back and fought valiantly with their colonial masters during World War I. But when the war ended, the League of Nations was founded in around 1920. There was only one African state at the table, that was Liberia. And of course, if you fast forward a few years later, you got Ethiopia in 1923, Egypt joined in 1937, and the rest of the continent was part of the British Empire, the French Empire, and Germany, Portugal, you could go on with the European masters. But the adoption of the Charter represented a big shift. There's a new dawn. And there, the light that's shown essentially can be shown in at least concrete ways. First, you had the development of the principle of the right of self-determination as a normative legal framework that made the independence of African states and the recognition of individuals as subjects of international law possible. Secondly, and I'll come back to this point in a moment, the UN was able to set up institutional machinery, starting first with the ad hoc committees on decolonization and later on a permanent committee on decolonization. And the responsibility there was to push for the right of self-determination, to be a meaningful thing for people in Africa and around the world. And thirdly, as a result of having a seat at the table, Africans and other formerly colonized peoples were able to push for representation within UN institutions. The arrival of those states actually fundamentally impacted the organization. They called the organization out to hold to the promise that it made to all of them in the Charter. And we know when you think about this aspect of the promise of self-determination, there was an aspect of it that dealt with the statehood and recognition of those states, but there's an aspect that was really fundamentally centered on the idea of human rights. And obviously this meant that African states now could assert some kind of legal personality. Of course, it meant that African states could have that seat at the table that they were not able to have in the League of Nations system. And you see that embraced in Article 1.2 of the Charter, which speaks of the equal rights and self-determination of peoples. And you have a number of substantive chapters, about 3 of them in the Charter, that really address, this is chapters 11 to 13, in, of course, the paternalistic language of that time. But if you look beyond that, the bottom line was they're pushing for international cooperation so that you can have an organization that works for everybody. And the idea of decolonization obviously found concrete expression through the Trusteeship Council and the role of the C24 and so on. Self-determination then ultimately became, if you will, this principle that got embedded in the UDHR in 1948 in Article 1, and that was significant. We saw that if you go past right past the UDHR, we got the International Bill of Rights, and obviously we were now trying to find that binding instruments, and you had Common Article 1 of both the ICE, SCR, and the ICCPR, both of which made self-determination an express human right and affirmed the importance of this right for all peoples. In the end, of course, there's a component of that the Bill of Rights added, which was so effectively recognized that you have to have a right to control your resources and to be able to determine your future freely. And finally, there was an aspect of it which is about self-governance and getting all these territories that were formerly governed by others to freedom, so to speak. We obviously, and I think Patricia mentioned this earlier, had that resolution from the GA in Declaration on the Granting of Independence to Colonial Peoples, which of course is fundamental and was a big part of that conversation in the Chego's advisory opinion. So while in the end, there are all these mechanisms that came out of the UN, both in terms of the legal framework, but also the follow-up mechanisms, especially centered around the General Assembly, the UN was able to accomplish for Africa, and Africans were able to use the UN as that global legal forum that my dear colleague talked about earlier. Let me end with that note of caution that I wanted, because I recognize that I don't have enough time, and maybe we could get other opportunities in the future. The issue of representation and reform and effectiveness of the Security Council. Today, we all know that the Council has been quite effective in a number of situations. And if you think about the Yugoslav situation, think about Rwanda. In a sense, they came back to clean things up when things went wrong, right? Because the UN was not able to act. We got the ICTY, we got the ICTR, and today we have a role for the Security Council in referring situations to the ICC, and we got Darfur and we got Libya out of the Security Council. But there's more that could be done by the Council, and that means we have to think about how to make the Security Council more representative and more effective, and that's where the issue of Security Council reform comes from. And of course, African states have been pushing their own ideas. There are many ideas about reform. The bottom line and takeaway that I want to make is that we need to address this issue so that we can get that organization being more effective in the next 75 years in the way it has been in really building a robust legal framework to bring us to the world that we have today. Thank you, Leila. I'm sorry I went a little bit longer than I wanted because we don't have too much time.
You were all fantastic, actually. We just needed 90 minutes. And with the Zoom format, we've kept things shorter because our attention spans are all shorter. I saw some great questions in the chat. Do we want to, you've spoken about the Security Council, we've spoken about cyberspace. Tim Sellers has said, for all panelists, what's the single most important thing to be done today to advance the principles and effectiveness of the United Nations? Why don't we do a lightning round and each one of you answer Tim's challenge, if that's okay. And Charles, since you went last, the last shall be first, and we'll start with you and just go right backwards to Larry, and then I'm afraid we'll be out of time.
Okay, very quickly, and I just already said it. So thanks to Tim for the question. Security Council effectiveness. We need to improve the Security Council. We can do better.
Okay, thank you. Patricia.
Thanks. No, I think that's really the million-dollar question, and it doesn't have a legal answer. For me, it's political will from world leaders, from politicians, especially in the Security Council, but not only in the Security Council. So to be very short, political will.
Political will, better leaders. Christian.
Well, I agree with that, but I think to complement that, what everybody can do, including everybody in this call, is, you know, to talk to your politicians. Tell them that this is what you want. That's your expectation. That you want them to make a political investment in the UN and to live up in their own actions to the principles of the Charter. Because this is how you generate political will. Political will is not something that falls from the sky, and you know. What we know is that the UN is very popular with people, and the SG himself has said, you know, very honestly, sometimes I wonder why we are so popular, but the UN is popular and with all its you know, flaws and all. But you know, the pressure needs to come from the people on the governments and on the policymakers to actually live up to what they have signed on to.
Thank you. Good point. And Larry, you're muted, my friend.
Yeah, let me unmute. I agree with everything that's been said, but to put it in more precise language, actually, I really liked what Christian said before. I think the issue is accountability of the permanent members. The permanent members say they have this huge responsibility on their shoulders. They have to maintain peace. It's not a privilege. It's a responsibility. Well, make them be accountable for that responsibility. Article 24 says the other members confer this responsibility on the, so as as Christian was saying, have them report back to the General Assembly.
Mm.
With the political will, have the General Assembly adopt resolutions and procedures to hold the council and its permanent members responsible and accountable for what they're doing, and explain why this majority resolution was vetoed. How did that help? Anyway, that's
fantastic. That's a great way to end. Accountability, talk to your political leaders, and support the United Nations. 75 years is pretty significant for an institution that was built during a war, as Larry told us. Thank you so much to all the panelists. Thank you to all of you who got up early or stayed up late to listen. We are going to transition now to a different Zoom room for the ABILA members meeting. I've put the links in the chat, or you can find them on the arbitration place landing page. Thank you all so much. Thank you to my panelists. You are terrific. And see you in the different Zoom room in a minute for our annual members meeting and award ceremony. Thank you.
Thank you, Charles, Patricia, Christian, Leila.
Thank you. Thank you.
Thank you so much.
Panel.
Great pleasure.
Very
Thank
good.
you.
Thank you.
Bye-bye.